Chapter 8, Mandatory and Directory Statutes. Mandatory and Directory Classification of Statutes. Importance. What effect should be given to the mandate of a statute? Mandatory and Directory Statutes. Generally, mandatory statute commands either positively that something be done in a particular way or negatively that something be not done. It requires obedience, otherwise void. Directory statute, permissive or discretionary in nature and merely outlines the act to be done in such a way that no injury can result from ignoring it or that its purpose can be accomplished in a manner that other than that prescribed and substantially the same result obtained. Confer direction upon a person, not performance of what it prescribed will not vitiate the proceedings therein taken. When statute is mandatory or directory, no absolute test to determine whether a statute is directory or mandatory. Final arbiter, legislative intent. Legislative intent does not depend on the form of the statute. Must be given to the entire statute, its object, purpose, legislative history, and to other related statutes. Mandatory in form but directory in nature. Possible. Whether a statute is mandatory or directory depends on whether the thing directed to be done is of the essence of the things required or is a mere matter of form. What is matter of essence can often be determined only by judicial construction. Or consider directory. Compliance is a matter of convenience where the directions of a statute are given merely with a view to the proper, orderly, and prompt conduct of business. No substantial rights depends on it. Or considered mandatory. Provision relating to the essence of the thing to be done that is no two matters of substance. Interpretation shows that the legislation intended a compliance with such provisions to be essential to the validity of the act or proceeding, or when some antecedent and prerequisite conditions must add prior to the exercise of the power or must be performed before. Test to determine nature of statute. Test is to ascertain the consequences that will follow in case what the statute requires is not done or what is forbids is performed. Does the law give a person to alternate choice? If yes, then it is mandatory. Depends on the effects of compliance. Or if substantial rights depend on it and inquiry can result from ignoring it, intended to the protection of the citizens and by disregard of which their rights are incuriously affected. Mandatory or purpose accomplished in a manner other than the prescribed and substantially the same results obtained directory. Statutes couch in mandatory form but compliance is merely directory in nature, or if strict compliance will cause hardship or injustice on the part of the public who is not at fault, or if it will lead to absurd, impossible, or mischievous consequences. If an officer is required to do a positive act but fails because such actions will lead to the aforementioned, he will only be subject to administrative sanctions for his failure to do what the law requires. Language use. Generally mandatory. Command words: shall or shall not, must or must not, ought or ought not, should or should not, can or cannot. General directory. Permissive words or may not. Use of shall or must. Generally, shall and must is mandatory in nature if a different interpretation is sought, it must rest upon something in the character of the legislation or in the context which will justify a different meaning. And that is how the introduction of our report. May I present to you Mr. Dabu to discuss more about mandatory statutes. Thank you with Ma'am Perla Blanco and Nueva.